was illegal was that it was motivated by an ulterior motive. It is grossly unfair that the minister is here. This is his first opportunity here, that he does not tell the Commission and the nation that he is innocent of corruption.
How long do you think
this is
you're
the last
going
question.
to be?
No, this is the 206 is the last question.
Just. Mr. Tembeka, sorry. Mr. Ngcukaitobi, for two reasons, I will disallow the question. One,
then I have no.
Thank you.
Mr. Chairman, I promise you don't need to give any reason.
Any reason. Thank you.
If
thank
the
you,
order
thank
is
you.
to disallow it, I have no further questions.
Thank you. Thank you.
Thank you, Chair. Perhaps on that point is the right place to start.
With what?
The point, Mr.
Yes.
Ngcukaitobi's last point, the re-examination issue.
Yes.
And just to highlight that, as the Chair pointed out, there was an agreement.
May I find out to what end you are addressing, seeing that I've already disallowed the question and Mr. Ngcukaitobi did not even
No, I'm
want
starting
my reasons for it.
I'm starting at the question and I'm making my way back.
Yeah.
Because his reference to paragraph 208 was not the start of having strayed way beyond re-examination, but it was the end. And I would like to put my point across. The moment Mr. Ngcukaitobi's re-examination went beyond the establishment and disestablishment of the PKTT, he went beyond the parameters of the agreement reached. The issues that he raised, there was references to Mr. Matlala, the relationship with Mr. Matlala, with Mr. Mokgotsi, with the contract, I take it as a 360 million subs contract. All those matters appear from page 64 of the minister's statement under the heading allegations of improper motives. And that is precisely where the deal that we struck because of time pressures, we drew the line. Under that heading, it's allegations, alleged association with Mr. Musi Ketmatlala, knowledge of the 6 December 2024 operation, knowledge or involvement in December 24 arrest of Mr. Katiso Molefe, the 360 million subtender, improper relationship with Mr. Brown Mokgotsi, Zama issues in Stillfront. It's a whole list of them. half of which Mr. Ngcukaitobi has touched on in re-examination, but none of which will be found in the transcript, in the evidence when it was led by Mr. Mtunu. I had to put that on record. And like I said, Chair, I bit my tongue. I resisted. I did not want to disrupt Mr. Ngcukaitobi's flow. And I must say, at some point, I was a tad desperate, hoping that the commissioners would come to my rescue. But, so what has happened is a topsy-turvy process, permitting Minister Mtunu to be re-examined on evidence, firstly, that was not led. He's got those, his responses to those allegations in the statement. He has not been taken through them. He has not been confronted with any evidence that could be contradicting the position he assumes in his statement. None of that has happened. So now, on record and in public, he's had the opportunity to clear his name in circumstances where the evidence leaders have not fully articulated properly what the concerns about those issues are. It is exceptionally topsy-turvy, but it's all water under the bridge because it has happened. But I understood, and we prepared on the basis that at the second session of the inquiry, which will be in 2026, we pick up the engagement with Minister Mtunu precisely from the allegations of improper motives, and we engage with that. Chair, there is no resolution to my challenge, but it was necessary that I place it on record. Thank you.
Thank you for raising that. Perhaps you should have raised it much earlier, and we too should have stopped Mr. Ngcukaitobi much earlier. So we are all at fault.
Oh, no, thank you, Chair.
Thank you.
I take it that was by way of comment. I would like to engage with some of the issues that Mr. Ngcukaitobi dealt with the minister. Yes, in re-examination.
Re-examination after re-examination?
Well, he calls it a re-examination. I'm entitled to test.
The matters that you say ought not to have been raised.
No. The matters
those that properly fall
that
under re-examination.
Yes.
Does that happen ordinarily?
We call it a re-examination. If he were to have cross-examined a witness put forward by the evidence leaders or the commission, the evidence leaders would have been entitled to re-examine on those issues. It's just that in this process, we call it a re-examination in circumstances where I led the witness. I didn't cross-examine the witness, but yet we call it a re-examination. So it's a misnomer in truth. And I suggest that we should not be hung up on words and titles.
May we take an adjournment, please?
Yes, Chair.